we're just also crossing live to the Appointment Committee, where appearing before Parliament's Appointment Committee today is Justice Philip Mensah, appointed to the Court of Appeal in 2019 by the then President Nana Akufo-Addo. Justice Mensah has presided over several high-profile cases. Notably, he acquitted and discharged Dr. Kasiela Toforson and businessman Richard Jakba in the widely followed ambulance procurement saga, following the withdrawal of all charges by Attorney General Dr. Dominic Ayine. I want to take you live to Parliament for the vetting of Justice Philip Mensah.
Constitution, and they make a determination as to whether the Parliament, didn't have that power to do what they did. Beyond that, the Supreme Court is also seized with that power of hearing appeals from the National House of Chiefs. But before the case goes to the Supreme Court, the National House of Chiefs, the appellant who is challenging the decision of the National House of Chiefs must obtain the leave of the National House of Chiefs. If it is refused, that application must be repeated at the Supreme Court, and if leave is granted, that is why the party will have the right to file its appeal. There's other jurisdiction which the Supreme Court exercises, and that borders documents that must be, that affects the security of the state. If there's a case before a trial court, like the High Court, and there's an issue as to whether a document which must be produced is going to affect the security of the state, the matter has to be referred to the Supreme Court to make that determination. And when the Supreme Court is holding that session, they do it in camera. They also have what you call the power of prerogative of mercy. In that case, if the president is exercising his prerogative to set a convict free, and the president is not sure as to what must be done, the Constitution says that refer the matter to the Supreme Court for advice. So, Mr. Chairman, you can see that the jurisdiction of the Supreme Court is so wide that it has also created the opportunity for cases, more and more cases being filed in the Supreme Court. It may interest Mr. Chairman to note that a case that started in the lower court, maybe the district court, can even travel as far as to the Supreme Court. Of course, when the case on appeal comes to the High Court, and the person who lost is satisfied, he will go to the Court of Appeal. From Court of Appeal, if he loses again and he wants to go up, he can go to the Supreme Court, subject to the leave of the Supreme Court. So invariably, you will see that there are more and more cases, and as the cases build up and they are expensive, it's only fair and reasonable that judges must be recruited to deal with those cases. So if you ask me, the minimum number that I will recommend for appointment to the Supreme Court, given the nature of the work they do, they are related with so many cases. Therefore, I think I would suggest 20 as judges that should go to the Supreme Court, because as a matter of rule of procedure, and it is also even backed by the Constitution, when the Supreme Court sits in an ordinary case, the panel is 5. The president will sit together with 4 other Supreme Court justices. If there is the chance to have the matter reviewed, 2 more justices will be added to it. So even in ordinary cases, you will see that in each case there are 5 judges who will handle the case. So if you say that judges mustn't be sent to the Supreme Court, then it means that you are giving the court more and more, they will be starting with more and more cases and they cannot have. So at any given time, when the panel or the judges in the Supreme Court are about 20, then we are saying that we have about 4 sets of panel of judges to handle those cases. So, Mr. Chairman, I will say, in my humble opinion, given the cases that are in the Supreme Court, I will recommend that 20 judges will be appropriate. Thank you.
Thank you very much. Any supplementary question? You can ask a different question. Your limit is 3. If there is a follow-up, fine. But if it is not a follow-up, I'll give the floor to Honorable Anthony Imie.
I'm the chair of the Judicial Committee.
Yes, as the chairperson of the Judicial Committee, you can be given a number of questions to ask far above members of this. But if you have a follow-up on the question that you ask, I will allow it. But if it is a different question, you don't have a right so to do. Yes. So the follow-up was emanate from.
My follow-up question is, even with the existing numbers, people were complaining of packing judges at the Supreme Court, and you are proposing increasing the number to 20. Then that means you have to review the Constitution or educate us. Thank you.
Honorable member, the Constitution doesn't place any limit. There is no gap placed by the Constitution. Therefore, the number can be increased to 50 without revising the Constitution.
Nominee.
But the question that you asked, it is clear that there is no limit placed. So, very well. So, Honorable Anthony Imie, you have the floor.
Thank you, Mr. Chairman. Congratulations, my Lord.
Thank you.
My Lord, going through your CV last night, I took interest in particularly page 2 of your CV, your work and professional experience.
Yes.
I realize that you have risen from the ranks, from the rank of a court recorder and almost at the apex court. I would want us to do a little bit of exercise in view of your experience from the judicial service, not at the judiciary.
Okay.
My first question is, from your experience, do you think that premium is being placed on the judicial service in view of the fact that all trainings, JTI trainings, workshops, etc., majority of them are organized for members of the bench? That's my first question.
Thank you, Mr. Chair. I would venture to say that when we are talking about training or capacity building, it should not be limited to only the judges. Why? Because if the registrar doesn't know his work, the chances are that he can even mislead the judge. We have had accomplished registrars like Mr. Kankam, Mr. Benton, the late Benton. His son is now a justice of the High Court in Cape Coast. I can name them and name them. I'm a living testimony, as my CV will show. I had opportunity to go to school. And Mr. Chairman, permit me to say that it's very essential that an employer must always try to encourage the staff, and in this case, not, as I said, not only the judges, but also the auxiliary staff and the registrars. I had the privilege of working with judges. I was in Sekene High Court when I had the opportunity to go to school. I worked with a judge called Ansetrum. I owe Ansetrum a great of gratitude. May his soul rest in perfect peace. I was my judge, so I was the character to him. I was very, very committed to my work, and the man took interest in me. I may say that Justice Ansetrum, late Justice Ansetrum, was a prophet. Why do I say this? He told me that, Bright, go to school, and if you went to school, you were going to be a great lawyer. I didn't take it serious. But when the time came, I saw the wisdom in it, and I applied myself to what he said. So I had the opportunity to go to the university in 1988 to read Diploma in Public Administration. I went back to Sekene, and then the following year, I had a chance to then go to the law faculty to read law. Went to Makwala to do my professional course, came out, and then went back to the service. Started as a magistrate, and I haven't looked back. So, and I must say, with all due respect, that my work has always spoken for me, and the records are there. It was because...
So, my lord, we don't intend to keep you here for long, so be brief.
So, what I'm saying is that I will say that when we want Ghana judicial service to grow in these months, we need to, one, build the capacity of the judges. There's this myth that the law is in the bosom of the judge. But if you, the judge, you do not educate yourself, how would the lawyer come and say that the law is in your bosom? So you need to educate yourself. Two, the infrastructure of the service. When you go to the hinterlands, they are so in some. I started from Mensah also. We were, so we need, and with your approval, please, when our budget comes here, I'm pleading, don't cut our budget, approve for us, so that the Chief Justice will use that to, acquire more, build more courthouses, renewed office accommodation, resident for the judges, because when you work in a serene environment, that even gives you the edge to work hard. I also think that there must be some reforms even with our laws. The laws that we are using, they must be overhauled. For example, the Act 30 was passed in 1960, and there's a need. Now we are in 2025. Some of the provisions have saved usefulness, so we need to, amend some of them so that there will be speedy recovery, speedy trial of cases, and so forth and so on. So my experience has shown that I will give premium to capacity building, and not only judges, but also the staff, and particularly the registrars. Thank you, Mr. Chairman.
Any follow-up?
Thank you very much. Yes, I have a follow-up. So you would agree with me, my lord, that there hasn't been proper, for instance, orientations, proper trainings, proper in-service training for persons like registrars. You agree with me?
To some extent, I will. But to a larger extent, I will also disagree, because we have Judicial Training Institute, and what it does is that it organizes courses periodically for judges and the registrars. I have even trained some registrars of the Court of Appeal and court clerks. So, and in recent past, some registrars were sent to the UK to undergo some studies. Well, they said rapes or rape, I've forgotten that word, but all in an effort to build the capacity of the register. So it's not only the judges that these courses are offered to them, but also to the registers as well. But of course, the JTR, that is the Judicial Training Institute, must be resourced so that they can organize more and more courses for the registers. Thank you.
Thank you very much. Any further questions?
Yes, my Lord, can you tell this committee how often does the JTI organize capacity building workshops, for instance, for registrars? Let's limit it to the High Court.
Well, I will take that to be a fresh question. So, question number 2.
I know for a fact that they do organize courses for the registers, but how often I cannot tell. Thank you.
Is it the case that when registrars are appointed, no form of orientation is given to them before they assume office?
To a very large extent, I would say yes. Thank you.
I don't remember your last question.
A follow-up to this one. That was the second question. So I have a follow-up.
You want me to treat it as your third question?
No,
so that you ask a follow-up
to
on
the
this.
second question. The last one was the second question.
Yes.
So I have a follow-up to the last question.
That is the training for very well.
Yes, now, my Lord, would you advocate that the budget for the judiciary is prepared in such a way that enough funds would be set aside for the training of both the judiciary and staff of the judicial service? Would you advocate that?
Thank you. In fact, that system is already in place. Parliament has given the judiciary part of the revenue that we generate to oversee our revenue cost and the rest of it. But you see, it's not enough. So, like Oliver Twist, we are saying that more and more resources must be given to the judiciary so that we can work efficiently and effectively. Thank you.
Thank you, my Lord. Now, from the internally generated funds of the judiciary, 30% is retained, while 70% goes to the government. In view of the fact that the judiciary is always struggling to meet its demands, would you advocate the uncapping of the funds so that the entire 100% of funds generated would be left for the judiciary to do business with?
Subject to the fact that that is not capping, you may proceed to answer the question.
Mr. Chair, can you repeat the question for me?
Very well, my Lord. My Lord, what I mean is, funds generated from the judiciary keeps just 30% of the said amount for its use. The 70% goes away to the government. What I want to find out from you is, in view of the fact that the judiciary is struggling to do its work, do you think that it would be appropriate for some law being passed, some permission being granted for the judiciary to retain everything it generates for its use?
Indeed, it would be a good idea if that was done, but I'm afraid the revenue that we generate is also backed by law. It must go to the consolidated fund, because it is from the consolidated fund that the government, applies to its activities, including institutions of state and the judiciary. So, to say that the judiciary should retain 100%, I will not advocate for that, but I will say that maybe about 50 or 70% must come to the judiciary. Thank you.
Thank you very much. I will then give the floor to Honorable Bede Awantanzuma Azidi.
Thank you very much, Honorable Chairman. Congratulations, my Lord.
Thank you.
Yes, my Lord, I've gone through your CV, and I've also listened to you. Honestly, there is absolutely no reason why you should not be appointed a Supreme Court judge.
Thank you.
You have done all that it takes to become a judge, right from the magistrate through the ranks at the Supreme Court. And I think that I will not worry myself about whether you are qualified to be a Supreme Court judge or not. You are. And so I have no questions for you, my Lord. As far as I'm concerned, you are fit for the job and you are fit for purpose. Thank you.
Thank you.
Congratulations.
Thank you very much. It's now the turn of Honorable Tambuli. You have the floor.
Thank you very much. My Lord, good morning and welcome.
Thank you. Good morning.
And congratulations, my Lord. My Lord, I heard you talk about the jurisdiction and the workload of courts in Nigeria, Federal Republic of Nigeria. And I want us to do a bit of comparison with ours here.
Okay.
So the Nigerian Constitution 1999 as amended, and in their case they call it sections. Section 2302B of the Nigerian Constitution provides, and I quote, "The Supreme Court of Nigeria shall consist of such number of justices of the Supreme Court, not exceeding 21, as may be prescribed by an act of the National Assembly." In Ghana, ours is in Article 1281. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. End quote. So, in other words, they have a ceiling, but we have a floor. So, at some point during the presidency of President Buhari, they even had 13 justices of the Supreme Court of the Federal Republic of Nigeria. But is it sustainable? And having regard to the fact that Article 128 is not an entrenched provision. The entire Chapter 11 has Article 125, 127, 145, and 146 as the only entrenched provisions. Do you think we should do something about this? Especially having regard to the fact also that 230 million people reside in Nigeria and about 32 million in Ghana. We have not less than 9. They have not more than 21. Don't you think by reason of these numbers, ours is a bit on the high side and potentially can even go way higher? Thank you.
Thank you, Mr. Chairman. I will start off by saying that if there should be need for expansion or capping of the Supreme Court, I think that there must be a wide and expansive consultation among all the stakeholders, lawyers, GBA, constitutional lawyers, I mean, the academia, even the political parties themselves, so that we will all come to consensus as to what we must do. And if there's a consensus that there should be a cap, then the law has to be amended. Fortunately, as we said, I also looked at the law, and that is not an entrenched provision of the Constitution. So the amendment, as it were, can be done without much difficulty, except that, as I advocated, there must be a very wide consultation. I brought this report, an annual report of the Judicial Service, and as at June 2023, this report was issued to us last week. 595 cases were pending in the Supreme Court. So when we are talking about capping, we must also take into consideration, as I've said already, the number of cases that are in the Supreme Court pending for attention. Thank you.
Thank you, Mr. Chair.
Any follow-up?
Follow-up question.
The ground rules.
I acknowledge, the ground rules. In view of the expansive jurisdiction of the Supreme Court, chieftaincy, jurisdiction, election, Supreme Court, presidential elections, and so on and so forth. Now, don't you think that there is need for us to stop the jurisdiction somewhere of the jurisdiction of the Supreme Court, especially, you can take, for instance, interlocutory appeals. Rules of Court Committee can, by CI, come up with something. Can you propose some limitation to the jurisdiction of the Supreme Court? Which jurisdiction do you think should be set aside and at the Court of Appeals? And then which one should continue to remain with the Supreme Court? And by the way, at some point, the Supreme Court of Nigeria had over 10,000, pending cases. At some point in 2022, over 10,000 pending cases. I thank you, Mr. Chairman.
Thank you, Mr. Chairman. See, I will say that first and foremost, the Court of Appeal must be very strong. I mean, being strong means that we need judges who, they are doing their work very well, I must admit. But we must make it stronger than now, so that some of the cases may not travel beyond that. But there must also be conscious effort on the part of the legislature and then the Rules of Court Committee to ensure that, and of course we can't do that without, we have to subject the debate very wide, so as to see the number of cases that will go to the Supreme Court. Because, permit me to use the UK example. UK, most of the cases end up at the Court of Appeal. The cases that go to the Supreme Court will go there with the leave of the Court of Appeal or the Supreme Court. So you find that they do very little cases, and so the Supreme Court is always, they are not saddled with so many cases. So if that is what we want to replicate in Ghana, then the law itself must be amended so that some of the jurisdictions must be taken away. For example, if I should be given the opportunity to say, to recommend, the prerogative of mercy that is exercised by the president. I think that should remain with the executive. It shouldn't come to the Supreme Court. Because after all, the Supreme Court itself has pronounced that when it comes to matters of advice, the president may take it or may not. Thank you.
My Lord, with the leave of the chairman.
Please, he said the mercy, not writ.
Prerogative of mercy.
Mercy, yes, prerogative of mercy, which is vested in the president. The president may come to the Supreme Court for advice. And once the interpretation placed on the advice is not compulsory or is not binding on the president, he feels that it should rest with the president. Yes, 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 yes.
So that's one example.
Honorable Bafoewa, you have the floor.
Congratulations, my Lord.
Thank you, Chair.
My Lord, I was happy to hear you say that there is the need to build a strong court of appeal, so that a lot of the cases that travel as far as the Supreme Court will be reduced. My Lord, when you take the law reports of the Republic of Ghana, there's one observation you are likely to make. A significant number of the cases determined by the Supreme Court, by the Court of Appeal, are overturned by the Supreme Court. In recent history, if you even look at the number of judges being appointed from the Court of Appeal to the Supreme Court, it's indicative of how strong our Court of Appeal is presently. But this is the situation. Why are we having that experience? Because currently we say we have a strong Court of Appeal, yet a significant number of cases are being overturned by the Supreme Court.
Thank you, Mr. Chair. In fact, I haven't had the benefit of that research you are talking about. So let me file a caveat. I will not be able to answer directly why that is the case. If I've had benefit of it, maybe I can profess an idea as to why that is the case. Thank you.
Mr. Chairman, no question.
Thank you very much. Honorable Alikplim Akurubu.
Thank you, Mr. Chair. Congratulations, my Lord.
Thank you.
Yes, there has been growing concerns about expanding access by breaking the monopoly of the Ghana School of Law. There are a lot of people who have completed their LLB and are home. Some of us are even planning to go read law, but we get scared about what is happening. What do you make of it, or what can you advise for our students who have been home for many years and haven't been called to the bar? Thank you.
Thank you, Mr. Chair. The number of students that are trying to get to the law school has increased significantly, because now we have universities that are offering LLB courses. In our time, it was only the University of Ghana, and then from there you come to the law school, so the number was few. Now it has been expanded without corresponding maybe infrastructure to take care of all those students. So I believe that is why the numbers have swelled. Now proposing a solution, offering a solution to the problem, I would think that those who have already passed their LLB and are waiting to enter the law school must be given what we call an immunity. Immunity in the sense that they could be grouped and then given maybe depending upon how the General Legal Counsel are going to do it. I think they can put a system in place where the students can be, grouped and then they are given the chance to do the courses at the law school. Now we have Kumasi Campus Law School. I think UPSA is also doing the same. So if they are given immunity and all of them are offered the opportunity to go to the law school, because invariably everybody who has entered the law faculty to do LLB who wants to become a lawyer in the long run. And I do not think it would be fair for us to impede the progress of the students who want to come to the law school. So the system must be looked at again holistically. The General Legal Counsel, together with maybe the director of the School of Law, they need to sit down and fashion up. And of course, there must be, also a debate. The academia must also be involved because they also have a role to play. Somebody has suggested that the courses being run at the law school must be taken there to the law faculties. That is maybe solving the problem. But the question also arises that the courses taught at the law faculties, they give the students the basic foundation of the law, theoretical. What is taught at the law school are professional courses. So most of the courses there are practical. Therefore, if the law faculties have the capacity to run those courses with the oversight responsibility of the General Legal Counsel, ensuring that, because here too we are talking about quality assurance must be applied. So the General Legal Counsel must also get involved in some of these matters and find a solution to the problem. Thank you.
Thank you, Chair. My second question. Judges are seen not to have a social life because of the kind of work you do, pressure on you to read cases and run around. How do you balance your social life with your career? Thank you.
Thank you. The life of a judge is something which, unless you have come into a fold, you will, because the steps that you take, wherever you go, and the things that you do, you are in the public eye. So when we are also talking about trust in the system, you, the judge, you must behave yourself such that people will have confidence in the courts that they are coming for justice. It's not only that the justice must be served, but they must be seen that justice is being done. So, for example, if I'm a judge and I move my car and go around, taking on board all manner of people as my friends, it leaves room for suspicion and the rest of it. So sometimes you have to isolate yourself. Me, for example, I pick and choose my friends. And if I haven't traveled out of town, Sunday, I will make sure that I go to church. So my work and church. I believe yesterday, the last nominee said something which we were all amazed, that because of his work, his marriage has to suffer. That is the kind of we are to show. And the point is that even if you see a friend, a lawyer, you can't even go and shake hands with him because people will say that, he is the friend to the lawyer. So that is the situation we find ourselves. But you see, that is the job we have sworn to do. So we will manage it. Thank you.
Thank you, Mr. Chair. No further questions. Congratulations once again. All the best.
Thank you very much. Then I'll give the floor to Honorable Yaoboma.
Thank you very much. Congratulations, my Lord.
Thank you.
Chairman, full disclosure, my Lord has been a very good friend of mine for many years. And I'm happy to see you go up as the Justice of the Supreme Court. Even if you are going to spend a year there, we know what you are going to send up there. I wish you well.
Thank you.
My Lord, first time I appeared before you was about 14 years ago.
Oh, that's so.
I remember Republic versus Osei, Antonia Kuto Osei, Jambafo, also Professor Jambafo. And the former Attorney General was for Osei. Brilliant submission of no case, which you upheld. A 90-page submission of no case, which you upheld. And Osei got out of the woods. I've read recently some decisions of yours, the Amewu matter, the Atufosi matter, that I know you to be a very bold judge, regardless of who is before you.
Thank you.
And that is commendable.
Thank you for the observation.
That's very commendable. What gives you that weight and motivation? Because the kind of cases that I've read you handle and taking those bold decisions are very political in nature. The stakes were very high. I would have wished my colleague Bafo to have been around, since he said most of your cases are overturned on appeal at the Supreme Court. Some of these cases that you also overturned came from the High Court. So I would want to hear your views on some of them. The Amewu matter, the Osei, Jambafo, Atufosi and Co. So those are matters that you've determined already, so you can give us an overview. Thank you.
Thank you, Chair. In the Amewu case, is it what? Amewu?
Amewu. John Peter Amewu.
John Peter Amewu. That case is still sub judice. What came before us was for an application, interlocutory, for an application for interlocutory injunction. So the case itself is pending for hearing. The appeal itself is pending for hearing. So it will be unethical for me to say something about it. Thank you. In the case of Osei,
hello, do you still remember the facts? Talk about some rice importation from India.
From India, I do to some extent, but it's, as you rightly said, it's a long time ago. So what I would say is that in that particular case, or generally, my position has always been that as soon as I hand over my judgment, I don't think about them again. Because if you are dissatisfied with it, you have the opportunity to go out. So it will be very difficult on my part to discuss it now. Unless, so please, let's.
My Lord, I'll step it down
Thank you.
and ask you if you still have some good friends at the bar, because when you are at the Financial Court 1, anytime a case is brought to you and the lawyers discuss, they say, you are going to Justice Bright Mensah's court. On one serial. Even if he's dismissing your application, he'll even put a smile on his face if he just asks you to go out. Lord, all I want to entreat you and beg of you is to keep being yourself.
Thank you.
Keep being a firm judge.
Thank you.
And I wish you the very best. Thank you.
But you see, Chairman, please, my court is very friendly court. Very, very friendly. If sometimes thank you for the comments.
Yes, I'll give the floor to Honorable Haji Aladi Ayamba.
Thank you, Chairman. Congratulations, my brother.
Thank you.
So hard, riding through those ranks. Thank you. I think this is something that needs to be discussed with those up and coming. Some people think you must just get up and get to the topmost level. But here you are. Looking at where you came from and the issues that we have at hand, especially on the ground, when you go to our villages, for that matter, our districts, what is your suggestion about the fact that we don't have, for lack of a better word, let me say, lawyers around, where maybe in Pusiga, you have a case, you even need somebody, you may have to be calling Accra. We don't have the judges. Sometimes one judge is handling so many districts, or there may be only 2 judges in one region, and they continue shuttling, going up and down. What is your suggestion? What will you bring up to encourage whether those who are already trained professionals so that they will take up places that are deprived, or judges to accept postings to such places?
Thank you, Chair. I think the solution to the problem is that the conditions of service, particularly at the lower court, must be attractive to lawyers to start from the lowest bench. Quite often, lawyers who want to join the bench will want to join it from the superior court. But when we talk about the work of the courts, it's those down there who normally do the bulk of the court. Indeed, when we are talking about access to justice and quality justice for that matter, start from down there. So therefore, to attract lawyers to start from the lower ebb of the ladder, then it means that the condition of service must be very, very attractive. I myself, when I started, I was also started with going to other courts. It was because there were no lawyers available to be engaged. Not that they are not available, but they didn't find our conditions of service attractive to come to start from the lower. So the solution to the problem is that the conditions of service of the judges, particularly at the lower bench, must be attractive for the lawyers to start from there. I believe that if the conditions of service are attractive, many lawyers will join the bench. Thank you.
Chairman, my second question. Cases take so long in courts, whether rural, urban, whatsoever. Some even, eventually they die and the cases are not ended. They are not determined. Thank you for giving me the correct word. Are not determined. What is your suggestion to ensure that at least we make sure these cases are determined very fast so that we don't have so much at hand?
Thank you, Chair. There are so many factors that come into play when cases
delay in court. I will not go into that because I'm being called upon to offer an advice or suggestion as to how they may be addressed. The first is that the judicial service must get their system digitalized, because now the modern trends are that if we were to digitalize our systems, cases filed will be filed electronically. When they are filed electronically, the belief that we'll have to effect service, we'll also do it, the proof of service, if it is served, you will issue proof of service and then it will be uploaded into the system. So we will not get a situation where a belief, though has served a process, will not prove service. Once proof of service is not on the docket, though the process has been served, the judge cannot go on with the case, and that will mean that the case must suffer an adjournment. When we also talk about e-justice system, we are also talking about virtual court. In other jurisdictions, even in Africa here, Tanzania and Kenya have invested so much in the judicial system, such that once the cases are filed electronically and the supervision of cases are generated electronically, so the Chief Justice will not even have the power or has no control over who should sit on a particular case or the other. Which means that as soon as the processes are served and everything is in place, a judge who has traveled to his hometown, maybe I might have traveled to Amasma, and if a case is put before me, I will not have excuse to say that I'm not in Accra, so I can't do the case. It's virtual court. And sometimes you can also use Zoom to do those cases. If we were able to do that, I think it will be a leap forward, so that cases will be tried as expeditiously as possible. But if we feel that we must remain where we are, we won't get far. So that is the solution I would prefer to the problem on hand. Thank you.
Chairman, what I'm about to ask might not necessarily be in the Constitution, but is Act. There is this statement I've read in it that states that a child can have sex at 16, but can only marry at age 18. It has been baffling me because why do you think that someone has the right to have sex at 16, cannot marry at 16, but should wait until 18 because we say it's a law? Now, sex comes with so many things because you carry responsibilities when you go to have sex, whether at 16 or at 100. You may become pregnant, you may, a whole lot of things. What should we do? Should we bridge the gap between the 16 and 18 and make it that at least 18 is more acceptable, that the right for anybody to have sex is at 18, and when there is anything, even if you get impregnated, you could marry the one that you are interested in, or we should reduce it to 16 so that we don't even have that gap.
Thank you. I think the interment of which puts the marriageable age to 18 was thinking that by 18 years, the girl would be a mature person to be able to know her responsibilities so far as marriage is concerned. Now, why should a girl have sex at 16 and not be permitted to be married? There's more of a moral question, sort of. Because look, 16 years, what does the girl know? The girl does not know anything. But if she's 18, and the Constitution even makes, I describe an adult person as 18 years. So if you are 18, the presumption is that you have seen life a little to be able to be independent or think for yourself when you are married. But if you are 16 years and they are taking you for, I think it's quite. See, at 16, the girl must be in school. They should not go and follow a 45-year-old man. Thank you.
Sorry, Chairman. The response I was asking, with that, your explanation, I'm quite satisfied. But I need to know whether we should then look at, we should amend it.
Amend it to
18 years for both sex and marriage, or it should remain as a...
To amend it to
18 years, to 18 years.
Oh, then that the girl can have sex.
Have sex at 16.
Hey.
My Lord, I think if that is done, the defilement cases will be a lot.
I see. But the point is that when these girls wait to 18, that is the question we must also settle ourselves with. If he remains in chastity to 18, well and good. But you as a parent, you will be sleeping and your daughter will be somewhere else, which you have no idea about. How can you control her? So please, let the law remain what it is, at least for now. Thank you.
Thank you very much.
Thank you, Chairman. Thank you.
Yes, Alaji Omar, you have the floor.
Thank you, Chairman. My Lord, Philip Wright, congratulations.
Thank you.
My question is bordering on judicial or policy litmus test.
Judicial
or policy litmus test.
I didn't hear you well.
Okay. What is your stand on gun ownership?
Gun ownership. Gun. In fact, I think our laws are such that if you want to own a gun, first and foremost, you need to register it. So if your gun is unregistered, then you have already violated the law. And I'm sure that this is to prevent people from, using the gun not intended for the purpose for which the gun was acquired. So my position is that if you want to own a gun, first you must be an adult, and then you must also register it as the law requires. Thank you.
Thank you. The second question is, what is your view on the doctrine of separation of powers?
Separation of powers, it's, somebody would say it's a political doctrine where the three arms of government are given their specific rules to play. And that's overlap. It's overlap in the sense that you can't say that because you are a judiciary, you will not have anything to do with the executive. And that the executive will also not have anything to do with the legislature. In fact, the core idea of separation of powers is to ensure that the three arms of the three arms of government, there will be checks and balances. So no one arm will be controlling the others. So for example, as of members of this house to ensure that when the executive is going astray from what it is required or they are required to do, you have the power to say that no, this one you are going ultra vires your powers. The same with Parliament. If Parliament passes laws which are ultra vires their powers, the Judiciary should be able to tell the lawmakers that, look, here it didn't go well. You should have done this or you should have done that. So it's about ensuring that there are checks of balances so that there will be cohesion. After all, that is what good governance is all about. Thank you.
Please do. Thank you. My Lord, in recent past, the last few years, you have some interference and overlapping where Parliament is making decision, is not yet concluded, and yet the Judiciary jump on it to make decisions to stop it. Is that not usurping of or interference in the separation of powers?
Thank you, Chairman. The law, as I understand it, is that if what the Parliament sought to do has to do with interpretation of the Constitution, then the Judiciary is seized with that jurisdiction to go into the matter. It's not as if the Judiciary is becoming a schoolmaster. Of course, in any event, Parliament, you are masters of your own, what do we even say it? Masters of your own rules. So if the rules are fashioned in consonance with the law, and for that matter, the Constitution, I do not think the Supreme Court will jump onto your head and say that, don't do this, don't do that. So, I would say that that case in question that you are talking about, if it bordered on constitutionality and interpretation of some provisions of the Constitution, then the Supreme Court has a right to intervene. Thank you.
I wish you all. Thank you so much.
Thank you. I will then proceed to give the floor to Honorable Jerry Shaib.
Thank you very much, Honorable Chair. Honorable Chair, let me take this opportunity to welcome the Honorable nominee and Nana Doctor and all the. I have a parcel of land in that area, so by extension, I'm a sub-chief.
Is that part of assets that you have declared?
Mr. Chair, I was given the land last night. Thank you very much. Nana Justice, congratulations and you are welcome.
Thank you. Thank you.
Honorable nominee, you've been a registrar of the court, and I believe for a period before getting to the High Court and then the Court of Appeal. And therefore, you are versed with a lot of knowledge on judicial matters. Respectfully, would you recommend any judicial reforms to this committee?
Certainly. Thank you. I've already made mention of some reforms that we can put in place to ensure that cases that come before us are tried expeditiously. And I made a point of this e-justice system. I think the rules of court that we also work with needs looking at again. For example, the High Court rules, CI 47. Indeed, we had the previous one, which was promulgated in the 50s. It was only in 2004 that we changed it, and that has become our tool that we work with. Now, there are also inherent difficulties or problems with some rules of our engagement. For example, interlocutory appeals. I'm talking about interlocutory appeals, both in civil and in criminal. Interlocutory appeals, when a decision is made by a trial judge, while the case is pending, most often the party that is dissatisfied will want to go on appeal. In that case, and if he applies for stay of proceedings, it's certify the hearing of the case. So I want to suggest that, yes, they have the right to appeal, but there must time limits within which the appeal must be heard so that it doesn't affect the hearing of the case adversely. Now, coming to the criminal aspect of it, now it has become fashionable that if you are doing a case as a judge, when you cough, a party will want to go up. When you sneeze, and sometimes they go even as far as to the Supreme Court. Meanwhile, then the case will be pending. So I strongly advocate that the right of parties filing interlocutory appeals in criminal cases where the prosecution has not even ended its case must be stopped. And we can only do that through the amendment of the law, that is Act, talking specifically about Act 30. Now, another area which also needs reforms is our jury system. We inherited this system from our colonial masters, Britain, where they started this system. As I speak, India, some Commonwealth countries like India, Singapore, and South Africa, they have abolished the system. Why? Because it's not functional. Now, our experience in our jurisdiction has shown that that system has outlived its usefulness. So I would advocate that instead of the jury system, there must be assessors. Now, if you permit me, I will give one example. When I was in the High Court, I did assess, that was before my transfer to Secretary in 2015. I did a case where I had summed up the evidence to the jury, and as much as possible, I did it that everybody in the courtroom, or maybe those in the courtroom who understood what we were saying, anticipated that the jurors were going to, bring a verdict of guilty. They came out and said that the accused persons were not guilty. And you see, the law is also that they are the judges of fact. So their verdict is even binding on you, the judge. You may disagree, but you cannot open your mouth. You have to work with it. And there was a doctor who has been subpoenaed. I've come from Ankafor Psychiatric Hospital to give evidence in the case. The doctor was in the court when I was delivering my seminar. The man was so disappointed that he said that if that is what the jurors here are doing, that I will never come back again. He didn't come. So the case will have to be, I left it because I was then on transfer to Secretary. So we can give examples, but because of constraints of time, I will not do that. But I'm saying that in its place, we should establish what we call assessors. In assessors, the judges who will try the case will be 3, and there will be lawyers. I mean, there will be lawyers who have become judges. They will sit on the case. And we have it on our statute books when judges try treason and high treason offenses. It's assessors. We don't do it jury. Our jury system here is porous. Some of them have become professional jurors. So that is one area which I will advocate. Thank you.
Thank you very much. My Lord, I asked this question yesterday. I think it was Sir Dennis, my Lord Sir Dennis, that responded. But just opposing that with his response and yours, I'm looking at the issue of, for instance, the criminal interlocutory appeal, that maybe a suspect or a witness believes that whatever ruling you made or whatever consideration you made would affect him or her. And if it is not corrected at the point that it has to be corrected, you would end up giving a judgment that would convict him and others. You don't think that the issue of time is key? That's what you said. But are you in the position to propose the time frame within which such appeals should be considered? Which I think is very, very crucial. Because if, for instance, I'm able to know that I can get an appeal for an interlocutory matter so that the court can proceed to deal with a substantive matter, would you consider giving us an idea of what time that appeal should be considered?
In my earlier submissions, I did make a point that if a party is aggrieved with a decision by a court, because the case has not traveled to its end and it is still ongoing, then that will be an interrogatory decision done by the court. Now, it's tried that when a case has not come to an end, or when in criminal matters, when the prosecution has not closed its case, the judge has no power to convict. Therefore, if you want to appeal against an interrogatory decision, you will not be, as it were, at that stage, the court cannot convict you and sentence you. So earlier on, I did propose that right for parties, it could be the prosecution or it could be the defense, to file interrogatory appeals while the case is pending, must be reserved to the end of the case or at the end of the course of the prosecution's case. That one is allowable, I think, that so that the hearing of the substantive matter doesn't suffer. Now, if it comes to the time that we should allocate for filing of the appeal and hearing it, I will propose that when the appeal is filed, interrogatory appeal is filed, the registrar should be able to compile the appeal within 14 days. Because invariably, it's not every document that has been tendered in the proceedings that will have to be embodied in the record of appeal. It's only if it's an application, yes. It will take the processes that were filed in connection with that application, and then the decision of the court itself, that will be the relevant records that must be sent to the Court of Appeal. And when it is sent to the Court of Appeal, then the rules of court must also amend the rules to say that if it's an interrogatory appeal and it's of urgency, it's urgent, then that appeal must be heard within at most, is it at least or at most, 30 days, so that it will not badly affect the hearing of the substantive case at the trial court. So that is my proposal.
Very well, thank you very much, my lord. My lord, were you once a magistrate, and would you pray that career magistracy be abolished?
Not at all. I would rather advocate that the system must be, must be strengthened, for want of better word. Because you see, this career magistrate came about as a result of when the Courts Act was amended. First we were sitting as tribunals with, panel members. I think in 2001 or so, when President Kufuor came into office, the Parliament sought to reverse the system back to its former. So now, we had magistrate. Because of the vacuum that was created, most of the there were so many vacancies. So that was why at that time it became necessary for the then Chief Justice to fashion out this magistrate, a career magistrate system. And it is not, Ghana is not the only place that we have, applied this system. When you go to Nigeria and Zimbabwe, they have that system. And there's a career part where you can start as a career magistrate, and you, by dint of hard work, integrity, and your competence, you can rise to become chief magistrate, which is an enormous grace of a high court judge. Now, here, there's some difficulty with our system. Currently, because the service felt that we must encourage lawyers to come to occupy those positions. And as I said earlier on, the lawyers, when they want to join the service, want to start from the superior courts. So, as at now, there are about 70 plus more career magistrates still in the system, and those ones are in the hinterlands. And they do the same work as that of, professional lawyers who have become magistrates. So instead of scrapping it, it should be strengthened. They must be given the opportunity to also go to the law school, educate themselves, because when they come back, they also come and join the service. There is a second judge in Kumasi, started as a career magistrate. He had the opportunity to go to school, and now he's a second judge. So instead of scrapping it, because if you scrap it, and there are vacancies in the hinterlands, as Madam was saying, who will go there to, do this career magistrates who have been going pushed to the hinterlands to handle the courts there. And it's important that we should, encourage them to also come up with their competence. Thank you.
Well, that would be, I have my final question. And sitting in as a judge, Lord, what would be your role in curbing the menace of galamsey? What suggestions would you put forth? And how are you going to deal with issues that come before you, especially on galamsey?
First and foremost, we have this minerals and mining laws. And the offenses that the law creates are deterrent enough to punish people who are involved in galamsey. What is left is the implementation, the effective implementation of the law. So I think there should be a collaboration between the service and then the police or the enforcing authorities. After all, we are fighting a common cause. If we allow this to go on, and in the next 5 or 10 years, we are importing water because all our water bodies are destroyed. Can we bear it? One area I also want to maybe hammer or suggest is that there are foreigners who also engage in this galamsey activities, destroying our forests and the rest of it. You know, when they are arrested, especially these Chinese people, when they are arrested and sent to the court, the difficulty is that they don't speak English. Even if they can, you know, they understand English, they will refuse to speak English. And because the judges or the police enforcement agencies also are unable to speak their language, it becomes more and more difficult to get them prosecuted. So I will suggest strongly, or I recommend, that the judges who are in the areas where these galamseys are going on, the judges must either be taken to China for further studies in Chinese language, or they should fashion, the JTI must be resourced to bring experts to come and train our judges. That will also is another way of, because if the person has committed offense and he can't speak, you can't prosecute him. Then it's as well saying that, oh, let me leave him for him to go away. So that is the recommendation I will make. Thank you.
But Lord, why not get interpreters?
Oh, that is also good. It's another point. But you see, the interpreters themselves, sometimes they are also a problem. So if the judge himself understands the language, language, it will be better served for them to understand what he is doing, what she or he is doing, and for us to, you know, be able to curb the menace of galamsey. Thank you.
Thank you, my lord. But so, how does it mean that you want to deport a Chinese person involved in galamsey? What would be your stand?
This is a difficult question. Difficult in the sense that the power to deport is the executives. I'm not in the executive. So I cannot, with all due respect, answer this question. Because the discretion is the executives. Thank you.
Thank you very much, my lord. I wish you all the best. Thank you. Thank you, Chair.
Yes, Honorable Koku, Ruketega. You have the floor.
Yeah. Thank you very much, Mr. Chairman. Nominee, my lord.
Yes, sir.
Justice Philip Bright Mensah.
You are right, sir.
From Amosman.
Yes.
My neighbor. Your neighbor from Cape Coast.
I know.
Are you cool?
Yeah.
Going through your CV, just like going through your CV as many of us have done here, your CV is an epitome of what will be described as you have gone through the mill.
Thank you.
You have pretty much climbed the stairs through our courts. So obviously from where you will be sitting, God willing, you will have a much comprehensive view of the whole court system. And I have no doubt in my mind that you will do a good job.
Thank you.
For Ghana.
Thank you.
My questions this morning is on how we can improve the inefficiencies within the court system. In Ghana, even though we have district courts, which are supposed to deal expeditiously with matters, but we often hear that the courts are becoming like the circuit and high courts, I'm told.
Circuit and the High Court?
Yes.
The District Court?
The District Court.
I see.
We're talking about inefficiencies here.
Okay.
Do you think we need small claims courts which can deal with matters involving claims that are, say, less than 10,000 Ghana cedis, and deal with those cases in a day or a week maximum? Thank you.
Thank you, Mr. Chair. Indeed, the service itself has, over time, devised some means or strategies by which such cases. So, with all due respect, you are not the only one who has raised this question. In fact, even in Accra, there used to be small claim courts. The rationale is that somebody who has a small claim must be able to walk to the district court, Gaboso, where I also did my work there, so that you will not require the services of a lawyer. You can walk in there, and of course, the district court is a case, the court of summary trial, so you don't have to file too many papers. You go there, if it's about money, as you are saying, the person, the defendant will be served, and when they appear before the court, the magistrate will ask him, look, you owe this man, are you liable or not? If he admits that he is liable, then he will enter judgment there and then. So it's a very good suggestion, a good idea, but it will also depend upon our lawmakers here. If you give us money to be able to set up the courts, we will be able to set up this small claim court that you are talking about. Thank you.
Mr. Chair, thank you very much. Again, my Lord, I'll go to my second question. No follow-up question.
Okay.
But also relates to the same inefficiencies within our courts and how we can improve on that. And this time with technology.
Okay.
You did say earlier on that if we have, electronic systems within a court, we can improve on things. I think the problem goes beyond just the electronics, but
okay,
the whole data management of the courts. The data collection and the management of it. You realize that maybe the systems are not there, but I think it would be a good idea for the court to start getting people with expertise in technology to help, sort of augment the work that you do. And that the court should be looking at management systems, because the issue is to do with management. The reason why things are quite slow with the courts. So would you think that it would be a good idea to invest? I know you've done a lot of, you started many years ago to do some automation in the courts. Do you think you still need more investment in automating the court? To an extent, it cannot be 100%, but at least to a level that will make processes much faster than having some years, some cases sitting in court for years without any solution. Thank you.
Thank you. Certainly, yes. The government or the executive, for that matter, must make conscious effort to invest in this project. I said that in Kenya and in Tanzania, I'm told that when you want to electronically file your cases, you walk into what we call here communication center to do it. So if we have been able to also invest in the system such that it's across the board, across the length and breadth of the country, and we educate people as to how we should use the system. It will help us a great deal, because it will mean that most cases will be tried as expeditiously as possible. And when we are able to do that, I think the confidence and trust in the judicial system will soar up. So I will still plead that when our budget comes, please try to even top it up for us, so that we use part of the money to invest in this kind of, system to improve on our efficiencies. Thank you.
Follow up, Mr. Chairman. Would it be an encouragement as well if this investment comes and the system for judges and the whole judicial system to equip themselves with modern technology to be able to, again, be up to speed, in addition to perhaps introducing Chinese classes so you can deal with Chinese issues. Thank you. So they become quite rampant in our system now. Thank you.
Mr. Chairman, I do agree. I don't have any qualms about it at all. We should improve our system. Everybody, I'm sure this time, most of the judges, if not all of them, they know how to, use their laptop. So it's a very laudable idea, and I thank you for the suggestion.
I'm going to end with this. I just noticed on your CV that you're actually a chief of Amosman and the Nyufahene of Asebu traditional area. Would you let us know what your stool name or title is, please?
Mr. Chairman, I am Nanamwa the 8th, or let me say it in front of you. Nanamwa Otodo Awatri. May Amos my hands, and now may you find him or Asebu traditional area. Mama hear me. Mama hear not. Okay, the chief of Asamenfi, the 7th, he has come all the way from Asebu to come and support me. And the Queen Mother and the other chiefs, they are all here to give me their moral support. Thank you.
Justice, Bojo, but who's in the bill? Why he's in the bill?
Nana more ought to do our tree.
Nana more to do our tree.
No.
Please put your hair. Nana, Utinkwa. Thank you, Mr. Chairman.
My Lord, ni hao.
Ni hao. Ni hao.
Ni hao. Ni hao ma.
Chinese, hey, that's the first time I'm hearing it. Thank you, Chair.
It's greetings.
Oh, okay.
Yes.
And the meaning is what?
Like, how are you?
Oh, I'm fine.
I'm fine. Ni hao ma.
Ni hao ma.
Yes.
Hey, I see. Yes. Thank you.
Yes. Honourable members, I will proceed to give the floor to Honourable Patricia Piaget.
Right. Thank you very much, my Lord. Congratulations.
Thank you.
There's nobody but Mama Pat from Kumasi. Yes. We've been listening to you. Very interesting journey towards the judiciary. And one of the things I'd like to ask is for you to share with us your personal or professional obstacles you faced on your journey to becoming a justice of the court, and how your story might inspire the next generation of legal minds. Thank you.
Thank you. If I understood your question, you were asking how I rose to become a judge or
Yes, and share a story that will inspire the next generation.
Yes, I think first and foremost, if you want to become a judge, you need to make sure that you should be prepared to work hard. That is point number one. You're also talking about your competence and integrity. The work of a judge, you are settling disputes between feuding parties. So as the statement always go, you must not only deliver justice, but you must also be seen to do justice. My journey, I told you I've had a checkered history, but I want to give one example. You know, it is resilience. You must persist. In fact, when I did I read the diploma in public administration, and I had the opportunity to go to school again to read law. I had then been bonded over to serve the judicial service for 4 years. When I went back to Sekene, the following year I had the opportunity to go to the university. And there were all kinds of obstacles. But it took the intervention of a very good man, the late Justice Archer. He was then the Chief Justice, and I'm always grateful to him that he eventually permitted me to go to school, because I was a farmer man and I could not have gone to school without steadily repay. So I worked hard, and my philosophy in life has always been that something worth doing must be done well. In fact, permit me to emphasize that I started my career as a magistrate in Sefiri also. I didn't say that because that place is far from Accra, I will do my work as I choose and as I please to. No. Rather, I worked extremely hard, and I had the opportunity to even teach myself the law, because I was always studying the law. I was always reading my law reports. I was already reading my books. And I say this without any shadow of contradiction or whatever, that it was as a review also that the late Chief Justice Akwa identified me because of my hard work. So what I will say is that every magistrate, judge, whatever, you must work hard. Let your work speak for you, and let the promotion be on merit and not of any other consideration. Thank you.
Thank you very much for sharing this with us. My Lord, I want to tease your view on this issue. You know, in Ghana mandates retirement at 70. We have other jurisdictions that looks, especially even in America, that provides life. Extending Ghana's retirement age to 75, and whether that will require a constitutional amendment, and if you personally will support that change. Thank you.
Thank you, Chair. I will never advocate that the age of a judge, Supreme Court for that matter, be raised from 70 to 75. Why? In other jurisdictions that they retire the workers of life for life. So they will maybe run to the age of about 80 plus. Then, as you have all become aware, the cases that will go to the Supreme Court, they are few. In our jurisdiction, in our part of our jurisdiction, the Supreme Court is always dated with so many cases. And, madam, unless you want to be a lazy judge, you will find out. If you want to do the work and do it efficiently, you need to work very hard. And it is very stressful. So it's not advisable that when you get your retirement age of 70, then you say, I want to go to 75. If you don't take care, the 75 will not even reach. You will go and join our ancestors. So let the law remain as it is. 70, and then you will bow out from the bench. Thank you.
My Lord, what is your view on the Article 66? The 2-term for a constitutional term of 2 for each of Please read Article 66.
Okay, thank you, Chair. 661 says that a person elected as president shall, subject to clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn in as president. Now, clause 3 of that provision says that the office of the president shall become vacant, A, on the expiration of the period specified in clause 1 of this article, or B, if the incumbent dies or resigns from office or ceases to hold office under Article 69 of this Constitution. My view is that there's no ambiguity as to the terms that a president, an elected president, must, hold. So I will go by this law. I do not think I have anything to say in contravention of this, or I will not prefer any amendment.
We take it that you don't have any issue and you feel that 2 terms is 2 terms and it cannot be reviewed under any circumstance.
I think my position is clear, that the law is clear, so we should maintain it as it is. Thank you.
Thank you very much. My other issue, going by your answer to my second question, that you don't think that we should review the mandate for retirement. From your CV, I see a challenge because I'm really going through your calendar. And if I go through your calendar, I see one thing, that your effectiveness will be just for about 3 months. And yes, if going through the calendar, you go through holidays, vacations, and all that. So I am thinking that if we don't review that law, how can you be, because you are an institution, and therefore, if you have to, Ghana has to benefit your very existence in the judiciary. It is important that we look at that law. Thank you.
Thank you, Madam. Thank you, Chair. My position on the review of the age hasn't changed. I will stand still by it. Now, the challenge you are talking about, Mr. Chairman, there are precedents in the service. Some judges were appointed, and if you permit me, I will mention names. Justice Professor Kuji was appointed to the Supreme Court in August 2003, during the time of President Kufuor, and he retired in April 2004, a period of about 8 months. Justice Afrebu was also nominated from the Court of Appeal to the Supreme Court, also during the time of President Kufuor. He was there for only 1 year. So the president is there. I also think that promotions come from above. So, as a Christian, and if it has pleased the Lord for me to be promoted, even if it is 1 day, I think when I go there, I will do what is expected of me, and I will leave the service honorably. Thank you, Mr. Chair.
Thank you very much. Nanamwa, Utsirwa.
Honourable member is now the turn of the ranking member of the committee, Honourable Alexander Ponyuwaki.
Chairman, thank you very much. Honorable nominee, questions that I shall take you through. We'll look at areas such as perceived absence and reluctance of Ghanaian courts, particularly the Supreme Court, to engage in bold, transformative adjudication in matters of public interest, social justice, and constitutional enforcement. In fact, I have drafted these questions to test your judicial philosophy, your understanding of constitutional interpretation, and your views on the proper role of the judiciary in nation building. I wish you well as we proceed. Thank you. By the way, I heard you talk about your journey thus far in public life. Just in a very short phrase, say something about what you've learned, especially in very difficult moments, to inspire the youth of Ghana, who perhaps by unfortunate situation of their background are placed at the lowest ebb of fortune's wheel and feel that there's no life for them at all.
Thank you, Mr. Chair. What I would say in response is that hard work pays. So the youth must be conscious of the fact that
in shaping their life, hard work must be at the center of whatever they have chosen to do, whether career, job, and what have you. And as a person, you must also fashion for yourself. You must plan. You must plan for yourself. My journey started as a recorder. If I have not planned that, I also want to be like, and in fact, I was inspired by both the judges and the lawyers that were.
Enough, my lord. Enough, my lord. Thank you. Lord, your records have it that you are a chief, correct?
Certainly, yes.
You are a gazetted chief?
I am.
Since when?
2016.
Where you come from, did you ascend to that throne through maternal inheritance, or it was an honor, or through paternal inheritance?
Maternal.
Maternal, very well. So you've at all times been a lawyer, correct?
Certainly, yes.
Very well. Do you see the performance of your traditional role conflicting with your judicial function?
Very important and dear to my heart. So I've tried to manage as far as possible to ensure that I give equal attention to the two. Of course.
My Lord, it's enough. What I would suggest strongly to you is to have at the back of your mind the rule of brevity. I don't want to keep you for too long, but if you decide to be answering my questions with long answers, then you may stay for long, and the impression is created that the leader of the mighty minority is keeping you for too long. So just bear that in mind. Now, in your career as a judge, have you had the occasion of spotting talent at the bar and taking interest in directly inspiring such talent, including nurturing them to rise in the profession?
Thank you for the question. Indeed, the questioner himself was practicing in my court. I had then come from Kumasi, and he has also come out from the law school. Look, the point or the habit I have cultivated over time is that I always want to encourage young practitioners to have confidence in themselves. It's not good that as a judge, if a lawyer came before you, and a junior lawyer for that matter, I mean, we are all prone to mistakes. If a junior defaults, then you'll be shouting on the person. It has put some potential but brilliant lawyers shy away from practice. So I try to, from Kumasi right down to Accra here, and even in second aid, you can check. And you are testimony of that. Thank you.
Lord, now let's look at the role of judicial activism in a constitutional democracy. What is your own understanding of the role of judicial activism within Ghana's constitutional framework? And to what extent should judges be willing to creatively interpret the Constitution to address emerging injustices or legislative gaps? The emphasis here is creatively interpret. In fact, I'm not singling out a particular judge for mention, but I've been reading his judgments lately. If you look at my Lord Kulendi's ruling, you can see a certain path. Okay? And you realize that he's pursuing certain path, perhaps because of his long years in private practice and from private life to public life, he has a combination of these and is shaping his approach in the law. I have seen your judgments, and I, to some extent, can say that your thinking in the law is towards that pragmatic approach to seeing things. However, quite broadly, I mean, for over 10 years, I have not practiced in your courts, and I have not had the benefit of reading your judgment lately. So I want to know from you, how willing are you to creatively interpret the law? We are aware recently that there's a bold decision that when a process is filed and it is served, although it may be praying for, that process may be praying for an injunction, until that is expressly granted, there cannot be that presumption that you should be stopped. That's bold and very creative. What is your own position?
My Lord, before you come into answer, a few minutes ago you've been asked to observe the rules of brevity. I would want to plead with Osahi Togbi to also observe the same rule in asking the questions. Please, you have the floor.
Thank you so much. Mr. Chair, yes, they say I should be brief as much as possible. But some questions will allow you to go into a little detail. Now, the case in contention...
I'm not limiting you.
Okay.
So please proceed. I mean, this is a critical matter that you should...
I do not think that that case espouse a general rule that if an injunction application is filed, will not stop a party from doing whatever he is doing. My appreciation of that case and the ratio in that case was that if it's as a constitutionally mandated body, then, of course, the law has been that the court can sparingly grant injunction against a constitutionally mandated body. So I believe it was on that basis that this thinking has come. I mean, and the law, is said that it's always evolving. So if the position formally was that you can't grant injunction in any case against a constitution mandated, now they are saying that even if the application is pending, you cannot stop the... that is the position of the law currently. And until the Supreme Court gets the opportunity to depart from that position,
But that was by way of example. So my question to you that how willing are you to be creative in your interpretation of the Constitution to address emerging injustices or legislative gaps? I mean, I want to know from you how willing you are to be creative in your interpretation of the law. As to the debate regarding your understanding of the ruling, we can use another forum to discuss that.
You see, Tufo and Atene has settled the law that our constitution is an organism capable of growth. In fact, in other jurisdictions like Australia, Canada, and the rest, in Australia they say that even the constitution is like a tree. It has to grow. Our constitution is the fundamental law of the land. And it's, apart from being a legal document, it's also a political testament capable of growth. So when the situation arises that we have to interpret the Constitution, the provisions of the Constitution, to meet the exigencies of the time, I'm all for it. I mean, what is the sense of a judge, especially when we are going to the Supreme Court? And no, I'm not a timorous soul. I'm not timorous. I will apply the law as I understand it and interpret the Constitution to suit the exigency of the time. So that is my view on that.
Thank you very much.
My Lord, so let me get this from you. What is your own understanding or your appreciation of judicial activism as a judge?
You know, there's this, they say that judges do not make laws. Of course, that is the general rule. But it's also tried that where there are gaps, it's permissible that the judiciary will grease those gaps to make the law understandable, you know, for everybody to, you know, follow it. Let me give a typical example. You know, if you look at, I think, Article 22, it is provided that Parliament should pass law on the property settlement when the Constitution comes into force within 6 months. Parliament has not done that, but it became necessary for a Supreme Court judge to espouse this principle of jurisprudence of in this case of Mensah versus Mensah. You see, you will call it as judicial legislation, but it was necessary because I do not know, the Parliament has then not passed the law, and the situation demanded that there should be something about the case. That's why jurisprudence of equality principle came in, and it was a judge who, being bold. And so if the situation calls for it, and I feel that it is Parliament who must do it and they haven't done it, or the law is such, it's so ambiguous that we need to oil it, put greases in it to make it understandable, readable. Why not? I'll be prepared to do it. Thank you.
Now, my Lord, let's delve a bit into Article 132, the supervisory mandates of our court, of the Supreme Court. 132, yes, please. That deals with Coraranto, Mandemos, certiorari, etc., prohibition and all. Now, my practice at the Supreme Court, I came across some inconsistencies in terms of the approach to this constitutional provision. And in fact, as a practitioner, anytime I had my case before the Supreme Court, certiorari application, and I saw a particular panel, I could straight away predict that this panel, they would not hear me. And at all times, I was never wrong. Because you could see that if this particular panel is presided, however meritorious it is, they will say, go on appeal. Why are you coming here? And in fact, the anti-Article 132 bench would always say that supervisory powers in 132 are discretionary. So they would not venture, however meritorious your case may be, because they want you to go through the appeal process because you have appeal as of right. And they will further argue that go through the mill. Whereas you also believe that invoking their supervisory right would lead to justice for the party who is aggrieved. What is your own view about Article 132? Do you hold a position that even where the error on the face of the record are so patent, you must discourage certiorari applications or prohibitions under 132 by telling lawyers or parties to go through the long haul?
Yes, my Lord, you may answer the question subject to the fact that some Supreme Court judges are anti-Article 132. So you may proceed to answer the question.
My Lord, hold on a second. Chairman, with the greatest respect, I don't want us to repeat what happened yesterday. If you have a certain appreciation of my question, you can take it with me privately. But this interjection has seemed subject to what I meant. If you go to court, I don't know about your practice at the Supreme Court, but I am an active Supreme Court practitioner, and all the judges know. If you go to the court, you know this is a pro-state bench. This is a pro-this. We know. Those of us who are very active, we know how they think. If the matter is on a certain direction, how they think. There are some law judges that when you go with a certiorari application, they will encourage you to go on appeal. So don't come in by saying that subject to anti, it is not derogatory. What I meant by bringing that one in was not to denigrate anybody. So please, let it flow, then we can make progress.
Well, I do not want our record to show that some Supreme Court judges are classified to be anti-32.
It is not. Maybe you don't understand it. It is not derogatory.
Please proceed to answer the question, man. Was that?
Oh, thank you, Mr. Chairman.
What is this? It's getting out of hand.
Mr. Chairman, are you listening?
Please proceed to answer the question minus that.
Yesterday we were calm. If he wants to discharge, I will stop. He should discharge him, let him go and have his way. History will record. And one day, they would also be in opposition and this thing will play to them. What is this? Enough of it.
Please, you have the floor. Proceed to answer the question minus that.
Thank you, Mr. Chairman. I do not know those judges
the chairman is talking about, that they are anti-Article 132. But you see, I think the practitioners should also be circumspect, because it appears to me that it has become fashionable that cases that are tried in the High Court or in the Court of Appeal, the least opportunity, the lawyers who want to go to the Supreme Court by way of certiorari and, you know, the prerogative, with prerogative applications, because they feel that that is shorter than, you know, going through the appeal process. But Mr. Chairman, see, there's this principle that the Superior Court, there's no case is above that of. So it has always been cautiously maintained that before you touch the decision of a Superior Court by judicial review, you need to be cautious. So the best option, to me, I think that is what the anti-132 provision chairman is talking about. Because they will take the position that once a Superior Court is a court of unlimited jurisdiction, they have, you know, it's presumed that the judges on that bench are presumed to know their law. Of course, as human beings, they are also prone to make mistakes. But if the matter is for an appeal, I think it will be better served if you go to appeal. Because when you go on appeal, you see, the Supreme Court, they will have the opportunity to write judgment based on the merits of the case. One is about certiorari. Certiorari, we are not talking about the merits of the case, but about procedural rules. For example, if it is established that the error was patent on the record that said that it was uttered by the powers of the court, that one is acceptable. Or if they didn't have the power at all. But if they had the power and they did the mistake in the exercise of that jurisdiction, the best option or the better option is to appeal. So my position is that 132, yes, but
my Lord, would you be the type who would hasten slowly in dealing with matters of certiorari, or you look at it case by case?
I will look at it on a case-by-case basis.
Very well. Let's make progress. Now, let me take you through constitutional mandates and judicial restraint. Our country's constitution grants broad interpretative authority to the judiciary under Article 2 and Article 130. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways?
Can you repeat the question again?
So, I'm saying that Article 2 and 130,
yes,
in your view, these provisions clothe you with those interpretative powers. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways? Now, I would give you one case.
Okay.
The Pani Lamte versus the Kojoka Adra versus Attorney General matter. My Lord, acting CJ wrote the judgment for the panel, and I will just explain to you. This had to do with public servant participating in our partisan political activities, and the contention of the plaintiff was to the effect that, yes, the 93-1, hold on a second. Because students are listening to us, I don't want to make a mistake. 91 to be, yes, it's here. 94, 3B, those prohibitions. Now, the contention of Mr. Agra in that matter, which had to do with the eligibility and the prohibition, who qualifies to be a member of parliament. So his case was anchored on 94 3B, which says that, let me read it in full. A person shall not be eligible to be a member of parliament if A, is prohibited from standing election by law in force in Ghana by reason of his holding or acting in office, the functions of which involve responsibility for or are connected with the conduct of an election, or responsibility for the compilation or revision of an electoral register. B, is a member of the police service, the prison service, the armed forces, judicial service, the legal service, the civil service, the audit service, parliamentary service, the statistical service, the fire service, customs, excise and preventive service, the immigration service, or the internal revenue service, or is a chief. Now, in this matter, Mr. Kojogadre's contention was to the effect that, yes, these have been listed, but there were officers in the public service, specifically Ghana Highway Authority and Ghana Education Service. And he does not understand why, if somebody is a member, a staff of Ministry of Education, the person is prohibited. Ministry of Health, the person is prohibited. Ministry of Roads and Highways, the person is prohibited. But if the person is a staff of Ghana Highway Authority, the person will say that I have not been listed. Now, my Lord Bafoboni took that conservative stand to say that, to the extent that those others have not been listed here, it means that the Constitution did not contemplate them to be part. I disagree with him, but I yielded. I've not seen anybody going back to really further tease the mind of the Supreme Court on this. So it still remains a law, and subsequently, those who are in the public service mainstream but not listed here are part of our partisan political activities. So my question to you, with this background, is to what extent would you say that the cautious approach in exercising this power has affected governance in one way or the other? Because obviously, I see some practical challenges here where a minister is instructing an officer as Ghana Highway Authority or GES and knows that the person is the constituency or regional chairman of a party and is in opposition. I feel that the court was too reluctant in dealing with this matter. What is your view on that?
My view is very simple. While the court has spoken, that is the law.
That is correct. I agree.
Yes. So I do not have any useful, addition to it.
My Lord, with respect, I'm not asking you to critique. What I'm saying is the basis or the gravamen of my question is the cautious approach. What is your view on this cautious approach to interpretation regarding governance? That's all. I only gave you that example to give a background because you said you didn't understand my question. You get my point now? Very well. Then
Honorable member, my Lord has answered the question that once the court has made pronouncement on the matter, he has no view on it. I think his answer is very clear.
I drew his attention to the fact that I wasn't asking him to critique the decision of the court in the Kojoga Adra case. I only introduced it to draw his attention to the mainstay of my question, because he had come back to say he didn't understand the import of my question. So I needed to give him that background. So I am not asking him to question the judgment of my Lord Bafuboni, who spoke for the bench. Please. Now I have clarified that what is your view on the cautious approach by the judiciary in exercises its power of interpretation on governance? That is my question.
Very well, my Lord.
Thank you, Mr. Chair. I do not think that judiciary in every case has been cautious in interpreting the Constitution to shape our governance or our democracy. Indeed, there are cases which the Supreme Court has determined that has even helped shape our good governance and democracy. And a typical case, example I can give is G.H. Mensah versus the Attorney General. In G.H. Mensah, the summary of the case was that, or let me say, it's bordered on interpretation as to whether the ministers which the then president wanted to retain them in his government during the second time to be, to carry on with their work without parliamentary approval, because President Warren has won the second term and he has taken retained some of the ministers. Now, there's this, the Minister of Finance at the time, I think Kwame Poposo, had prepared a budget which was to present to Parliament. And the issue rose up as to whether he has that power to appear before the Parliament to present the budget. There was debate here and there, and the then majority said that we are going along with it. And James Mensah said, no, let's go to Supreme Court for interpretation. They came to Supreme Court, and the Supreme Court held that the term or the tenure of those ministers ended with the term of the president, so that if the President Warren has not won the elections, it will mean that they would have gone away. So they have been ushered into a new, they said fourth what? First session and blah, 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 blah. So I think that was the second session.
You mean the second parliament?
Yes.
Rawlings 193.
Yes.
And then 196.
Yeah.
So that was the second, my Lord, just a moment, because of the little ones who are listening. So the second parliament of the Fourth Republic, you mean?
Good.
Very well.
So the Supreme Court that once their term of office or tenure of office ended with the first regime, then they cannot be maintained or retained as ministers. What lesson do we learn here? The Supreme Court held that the purported retention of those ministers violated Article 87 of the Constitution. So it prevented the occurrence of recurrence violations of the Constitution, the provisions of the Constitution. So that depending upon each case, and as you rightly said, it should be on case-to-case basis. So Supreme Court, they are pragmatic. After all, they are policy courts. They give directions to shape our good governance, rule of law, and the rest of it. So if they have been cautious, and they have the right to be cautious, if
it demands that they must be pragmatic. They have to do it. So that is my answer to your question. Thank you.
Very well, my Lord. My Lord, you've spent the better part of your adult life after your call to the bar on the bench. I once remember you in your court saying that though you, the judges, don't go out, but perhaps you are the first to hear of every public rumor or gossip. I remember you telling us in your court. What it means is that you are equally aware of criticisms that emanate from the public space when you speak to shape governance and public opinion. Lord, would you agree with the position by some critics that the Supreme Court of our country has had the occasion to miss opportunities to provide judicial leadership in advancing constitutional justice and or protecting fundamental rights?
The Supreme Court has neglected this duty in shaping the... Is that what you said?
Oh, my Lord.
Can you...
Very well.
Please.
Very well. So, you hear of criticisms. Definitely, even amongst you, yourselves, your judgment could go up and your brothers above you will say no. I am saying that the feeling that there are times that our courts have missed the opportunity to provide judicial leadership, which leadership would have helped in advancing constitutional justice or protecting fundamental human rights. Would you agree with me that we've had instances like that?
I disagree.
Okay. My Lord, much as I appreciate your answer, is it your case also that in all situations the Supreme Court has scored 100% in providing 100% judicial leadership?
I will not say that it's 100% because it's a human institution. Because the judges have the right to go right. They also have the right to err. That is why Article 129.3 even provides that when exigency comes or where there are situations that the Supreme Court will have to depart from its previous decision, they have the right to do so. They will not come out to say that they were mistaken anyway. But in doing so, they will require that there are exceptional circumstances for them to depart from their previous decisions. And then two, it must also be said that the exigencies of the time demand that they depart from their previous decisions. So I would say that being a human institution, they are prone also to make mistakes. They are human beings. I mean, and there's no judge under the sun whose decision has not one way or the other not be overturned. We are human beings. It's only God who is perfect.
Therefore, we've had instances of missed opportunities in judicial leadership. Now, my Lord, let me bring you back to this case you decided at the High Court. And if you can't immediately recall, I'll refresh your memory on that.
Which one is that?
Yeah, I'm yet to say it. I'm yet to. In the matter of Ninoy Odonko versus the Iyoko, I can give you the brief facts of the case, just to recollect, for your recollection. If you remember, we would proceed. But if you...
It's a long time ago.
Sure, that's what I'm saying. I understand. My Lord, in the Ninoy Odonko case, Iyoko had frozen Ninoy's account without notice to him. The man had traveled out of the jurisdiction. At the time his account was frozen. He came back into Ghana after some 5 years and made an application before you. Iyoko at the time had already expended the money which was in their exhibit account. Your ruling was to the effect that the time for him to apply was far gone, so time back, procedurally, you could not apply for the defreezing at the time he was. However, the argument that he was not in the jurisdiction, and in fact, when the matter went on appeal to the Court of Appeal, your position was sustained. A certiorari was also filed, and relying on the Supreme Court's earlier decision, in a matter I will remember very shortly, he was again denied because applying for certiorari, per the rules of court, you need to do so in 90 days. So this gentleman lost every opportunity at all levels because of the time factor. He was not in the jurisdiction, his money is gone, and his fundamental human rights had been infringed upon. His right to have access to his own cash in his account had been taken away from him without trial. My Lord, my position is that the approach in interpretation was rather unfortunately very strict in this situation of Ninoy Odonko. And I consider it as a missed opportunity for the judiciary to have exercised a judicial leadership to protect fundamental rights, because on the fact it was all obvious the man has not been tried, he was not even on notice, but he's been affected by time because he could not apply. Equity would not be for his benefit in that instance. What, my Lord, in the present circumstance, would you advise the interpretation approach should be, with this in mind?
In the first place, let me say that I'm very happy that my decision was affirmed. And when you went to the Supreme Court too, you were overthrown. But coming back to your question, you see, judges, I mean, it's right that we do justice according to law. We don't do justice according to emotions. The court that you came to for it was not a what do you call it, human rights court. You were not espousing human rights issues. Okay, you were talking.
But the equity will look at substance, not form.
Oh, but the equity follows the law. Equity follows the law. So if the law says that within 1 year, and we started the Financial Crimes Court, I together with this judge who is no more with us. We started, and that time the Eco law had just been passed, so we were involved in it. And I quite remember that there is a provision in, if it has been changed, I do not know because I left the court a long time ago. Under that law, if your account has been frozen and the ECO people do not prosecute you within 1 year, you have the right to come to court to challenge it and have your account defrozen. You see, I'm not sure about whether your client has then traveled out of jurisdiction, and if it did, it wasn't served with notice. I'm not sure about that. But what I'm saying is that once the law provided the time frame within which to come to court, and you were outside the court, look, and it's 1 year. If you stay abroad for 5 years and you come to court, how will equity help you?
Okay, my lord, Honorable Leader, before you come in, let me suggest that if a question is posed to the nominee and the nominee is answering the question, we should allow him to finish answering the question before we pose another question.
My lord, the case I wanted to cite to support the earlier point I was making was the NCS versus Intelstat case. Have you come across that case? It was a 3-2 decision.
NCA what?
NCS versus Intelstat. So it's the 2012 Supreme Court of Ghana Law Report. NCS versus Intelstat.
Interplast.
Intelstat. NCS versus Intelstat.
Yes, what happened in that?
My Lord, it was a matter on appeal that went to the Supreme Court through a certiorari application. And the application was mounted after the 90-day window provided. And this was a case that my Lord Bedegbe of blessed memory departed from his good brother Atuguba. It was a 3-2. He went with my lady who is now with the Council of State, I forgot her name, Akoto Banfo, my lady Akoto Banfo. It was a 3-2. My Lord, in view of your argument that equity follows the law, and the fact that the courts in this instance applied the limitation rule strictly, that yes, the person did not, was not in the country, but the fact that you were not in the country and the fact that the IOCO did not serve you notice will not inure to your benefit. The law says within 1 year apply. Now, if you read the Intelstat case very well, you realize that my Lord Atuguba was making an argument to the effect that the court would not sit idly by and watch statutory provisions being breached. Now, with this on mind, IOCO has breached the law. The affected party did not apply on time. You think that for this, his fundamental human rights should still be denying him because he was, quote unquote, indolent at equity, and that the law says if you don't do it in a year, you are denied.
Let me repeat that I'm not too certain as whether the applicant in that case was served with a freezing order or not.
My Lord, for records, he was never served. I mean, I say so on authority, and I can furnish you with your own ruling.
Yeah, so
later.
I just provided some guide as the chairman of the committee that when a question is asked, let's allow my Lord to answer the question, then we can interject. I believe that is the way we're supposed to go.
Okay, so maybe
at a later stage, let me have the benefit of that judgment you are talking about. But my position is that you didn't go to human rights court for enforcement of your human rights. Because if you went to human rights court, the perimeters are different from the ordinary courts, like the financial crimes court. They are quite different. And even the time limits, I think they are also different. So insofar as you didn't come within the rule, and equity will never come to your aid. Thank you.
It's okay. My Lord, let's deal with another issue that has to do with charting a judicial path for the future of our democracy. Because for me, I think we, the political activists, for many years, will rely on our courts to keep this democracy alive. And I say so with a lot of passion in me. Without you, the court, particularly the Supreme Court, this country's democracy will not survive. Now, with that in mind, what role do you think the Supreme Court should play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with choice between restraint and activism in cases of national importance?
To begin with, Chairman, are you listening to me?
Oh, go ahead, the chairman is listening. My Lord, you may proceed. The chair
Allows you to go on. You have distorted my thoughts. The question again, you ask the question, please.
My Lord, what I want to know from you is that what role should the Supreme Court play in shaping Ghana's constitutional destiny in the next 2 decades? And how would you define your own judicial posture if presented with a choice between restraint and activism in cases of national importance?
To begin with, I have sworn judicial oaths, and throughout my practice on the bench, I've demonstrated my fidelity in the law. Whether it's about activism or posture and the rest of it. Indeed, it is the duty of a judge to come out with a decision that resolves dispute. A party who loses the case may not be satisfied or happy with it, but that will have been your decision anyway. So I'm not so obsessed with judicial activism and the rest of it. The core business of a judge is to do justice. And having applied the law to the facts of the case, you need to ask yourself, is it reasonable? Is it conscionable? Is it, all the qualifications that make a judgment or a decision to stand the test of time? If, as a judge, you apply your judicial activism, or as you will call it, judicial philosophies and the rest of it, and at the end of it all, your law or the decision is not in consonance with the law, or I will say that then you have done nothing at all. It may be a bad law that you have espoused. So I will look at it from the pragmatic view that, look, I've sworn in judicial oath, and where it also comes to matters bordering the security of the state,
we also need to be, that is why the Constitution itself says the principle is that it's capable of growth. It's an organism capable of growth. So you take all these things into account before we can come out with a decision that will meet the demands of the times. So that is what I would say that is what I would say in response to your question. Thank you.
My Lord, now I want us to deal with the issue of democratic inclusion versus constitutional restriction. And I want to pick your thoughts on this. How should the constitutional disqualification of dual nationals from holding certain public offices be balanced against Ghana's democratic values of inclusiveness and political participation?
My position is that this has been pronounced on by the court, the Supreme Court. So I do not think it would be better for me to, once the Supreme Court has come out with a position on this issue, that is the law. If there is the need for the law to be changed, maybe the appropriate time will come. But for now, that is the law, and I abide by it. Thank you.
But do you believe in the principle of inclusiveness in political participation in the light of the law prohibiting dual nationals?
Dual nationals, so far as I understand the law, if you have a dual, you a Ghanaian and you also hold nationality of other country, there are certain positions that you cannot hold. So if the Constitution says that is it, that is the law, and it's not about inclusiveness. The law is the law. Thank you.
Now, my Lord, without prejudice to existing case law principles and emphasis, without prejudice to existing case law principle, what in your view constitutes allegiance to Ghana in the modern global context? And how should this understanding shape the legal treatment of dual nationals seeking public office?
You see, this allegiance, the issue of allegiance, it's borders on our security. So if you allegiance, at a particular point in time, it must be with one country. Because if you owe double allegiance, how do you help a situation where even those countries have an issue to deal with? So that is my answer. Thank you.
The honorable nominee, let me deal with the issue of diaspora contribution and governance. Let me pick your thoughts on it. In your view, in what ways can the law recognize the significant contributions of Ghanaians in the diaspora while maintaining constitutional safeguards for public service and national interest?
You mean Ghanaians in diaspora or?
Yeah, Ghanaians.
Ghanaians in diaspora?
Yes, that's correct.
Yes, they contribute significantly. But if they want to fully participate in our democracy, I think they should also take into account the fact that when elections are held, they must come here and also participate. I remember one case, I've forgotten the title of the case, where a Ghanaian in the diaspora came to Ghana to vote, and the EC was saying that the term for registering that candidate, that voter has passed, so it cannot be registered. He sent the case to the Supreme Court. And the Supreme Court looked at the merits of the case and directed that that voter must be registered. So, because they contribute, and I'm sure that we are all aware that when our president, or we are trying to, woo them to come home and contribute their quota to the growth and development of the country, especially the professionals. So we need to encourage that. I have no problem with it at all. Thank you.
Lord, I would want to pick your thoughts on comparative constitutional practice. Now, to you, what lessons or models can Ghana draw from other democratic jurisdictions in the eligibility of dual citizens to serve in parliament, cabinet, or security positions? You know that some countries embrace this dual citizenship in their laws. To what extent do you think, having regard to your earlier answer of the Ghanaians in the diaspora and their contributions to our national economy, do you think that we can draw some useful lessons from other jurisdictions regarding eligibility of dual citizens to serve in parliament and even in cabinet?
I will say that if there is the need to do that, we should do it. Of course, we then have to look at the law again and see if it has to be amended to take on board the proposition that, Chair, you are making. Thank you.
Now, again, without prejudice to case law, because I submit to the proposition that the law is the law. I submit to that. So, without prejudice to that, share your view with me. To what extent do you consider the current constitutional restrictions for nationals as being discriminative or incompatible with the principle of equality before the law under Article 17 of the Constitution? And you may refer to Article 17 of the Constitution.
Article 17(1), if Mr. Chairman you permit me to read, says, all persons shall be equal before the law. 2, a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or social or economic status. 3 says that for the purposes of this article, discriminate means to give different treatment to different persons, attributable only to or merely to their respective descriptions by race, place of origin, political opinions, etc., etc. My tip on this is that those in the diaspora, if it's about shaping our political space or what, they should come here. They should come home and participate. So if I do not think this article applies to them. That is my take. They cannot be said that they are being discriminated against. Thank you. Now, let's look at the issue of public trust. Risk management, public trust, on this same area. What legitimate concerns, in your view, may justify the exclusion of dual citizens from certain sensitive positions? And how should the law ensure that such exclusions are narrowly tailored and made proportionate? Narrowly tailored. The emphasis there.
Yeah, Mr. Chairman. I think certain sensitive positions, like, let me, if the example I'm citing may be far-fetched, permit me to do that. For example, if a president whose double citizenship I achieve. Because if he is a president here and he goes to the United States and he is also the prime minister, in whose interest is he working for? So I think that there are certain positions. The law, if the law says that this position should not be given to a person who owes two allegiances to Ghana and to so be it, because it will be in the interest of the state that those positions are held by the indigenous or those in the jurisdiction. Thank you.
My Lord, I have just two more questions, and I mean two more, then we should be done. The last on this matter. Now you're going to the Supreme Court. I know of one Ghanaian citizen who is so passionate about this matter. He's always coming to your court with cases. And definitely there will be some requests for reform and judicial interpretation. What role, in your view, should the court play in interpreting or potentially reshaping application for dual nationality restrictions in the light of Ghana's changing social, economic, and political realities? We live in a dynamic world now. Things keep changing. Going to the Supreme Court, would you suggest that we should take some new steps in reshaping the application of the dual nationality restrictions by revisiting the law?
I don't want to go into speculative analysis, but if I should answer the question, I would suggest that once the law, if you think that the law as it stands now needs to be amended, there's nothing that stops us from doing it, because even under the Constitution itself gives the parameters within which we should amend our laws. So if it's necessary for the laws on dual citizenship to change, given the exigencies of the time, I think it is appropriate to do that. Thank you.
Now, my Lord,
let's deal with the constitutional purpose of bail. I know the courts have come out boldly to say that there's nothing like non-bailable offenses anymore, and have gone further to say that bail should not be used as a punishment. Now, in your view, how should the constitutional guarantee of personal liberty under Article 14.3 guide the interpretation and application of bail, particularly when conditions imposed make it practically onerous for the accused persons? Our courts are still struggling on this issue of bail. People are complaining. Investigative agencies are granting very onerous bail that accused persons, suspects, not accused, suspects, practically find it difficult to meet. What do you think should be the best approach in dealing with this issue whilst you are guaranteeing the liberties of such individuals under 14.3?
Thank you. Mr. Chairman, if Article 14.3...
Yes, I have a follow-up. Yes.
If Article 14.3 of the Constitution is read in conjunction with Section 96 of Act 30, the paramount consideration has always been that the person being suspected or have been charged with an offense will make himself available whenever he's wanted by either the police or the courts. Now, case law also makes it quite clear and plainly that when the terms of the conditions are onerous, it's amount to denial of a bail, and bail should not be used as punishment. However, it is case by case situation where the person who is exercising the discretion to grant bail should take. There are certain factors. For example, if the person is a flight risk, if a person will interfere with the investigations, and the rest of it, it's not advisable or it's not permissible that the person must be granted bail. But if it's about, so that is it. It's an exercise of discretion, and it's, the law is quite clear on it that there's no precedent in exercise of discretion unless you want to say that it was done capriciously and the rest of it. So if the exercise of the discretion is fair, you cannot force the person. But let me emphasize the point that the basic rule in this application for bail is that it has to, the person who is exercising the discretion of bail must ensure that the accused or the suspect will come and stand trial or will avail himself whenever is wanted. Thank you.
My Lord, as a follow-up to end the day, you've made a very profound statement that there is no such thing as precedence. Of course, case by case basis, and you've given us a broad view as the conditions for grant of bail. But there are still gaps that must be addressed to allow for some certainty. With that in mind, what would be your own reflections on the current bail practices, which sometimes seek to undermine equal access to justice for suspects or accused persons from economically disadvantaged backgrounds, and how might the justice system better address such disparities, in your view? So, you know that the person is not a flight risk, but the person does not also, from where he's coming from, will not get a property, will not have somebody with a certain standing in society. And my Lord, just to share this with you, I have seen a bill term where the judge directed that the accused should get a police inspector within a certain jurisdiction to sign the bill as a bill condition, a police inspector. And then I have also cited a bill condition where the judge ordered civil servants within a certain jurisdiction, I mean like a district, you know, not from the particular district where the matter was being heard. And I asked myself, how unconscionable could this be? Is it really to grant the bail or not? So what are your reflections on some of these situations?
Thank you. You see,
my Lord, have you also cited those things that he has mentioned?
I haven't done that. But I was going to even ask him, he was talking about gaps. Which gaps was he talking about, so that I will be able to answer the question rightly?
You know, with respect, I referred you to situations where we access to justice for suspects who come from economically disadvantaged background, and how we can address this situation to create a better access to address such disparities. And it's the reason why I gave you that example, because the ordinary Ghanaian is still concerned about the terms of bail, how onerous they are, after the court decided that now all cases are bailable. So I hope there's clarity now, or I should still expatiate.
I've understood you.
Thank you.
I think in such situations, you will need to apply for the review of the court order. And if it is refused, you go up. Or you may want to even go to, if the case is pending in the lower court, you can go to the high court for Judiciary to have it quiet. Because as I said, I mean, bail is not used as a form of punishment. Therefore, if you think that it is onerous and you can't meet it, I think the best place for you to go is to go to the high court or a higher court that can, you know, look at it and then make a determination for the bail to be rescinded or varied, as it were. Because the law is that the paramount consideration in all this is that the person must come to court to stand his trial. Because look, if it's a police inquiry bail and the person ends up in court, the court would not say that because the police granted this bail, I'm going by it. The court will look at the circumstances of the case and will fashion its own bail conditions. And a judge who is informed of this law, the position of the law, that the purposes of a bail, so far as Section 96 of Act 39 is concerned, is that we need to ensure that the person came to court to stand his trial. I do not think Of course, when you start at first, you can do all sorts of things. As David said, when I was, is it David? No, Paul. When I was young, I did my things as a young person. But now that I'm old, so if you start as a magistrate, these are some of the things. But as you grow, and the experience will tell you that you need to, soften your stand in some of the matters. I mean, how would you say that the person you want to impose conditions of bail for which the person cannot, get out of? Because he must be given a free trial, a fair trial, and a fair trial means that you must give the person the opportunity to prepare for his defense and the rest of it. But if you keep the person in cells or in custody, how will he come to defend himself? So that is my position. Thank you.
Thank you very much. Honourable members, our revered guests, we've come to the conclusion of the vetting. But following some matters that ensue yesterday, when we were vetting Justice Sir Dennis Dominic Ajay, a letter was written to the GRA, and they have the response sent to the chairman of the committee. For the purposes of the record, I may want to read the letter verbatim so that it can be captured accordingly. The letter dated 17th June 2025 on the letterhead of Ghana Revenue Authority, GRA, addressed to the Chairman, Appointment Committee of Parliament of the Republic of Ghana, Accra. Dear Sir, task position of the Supreme Court nominee, Sir Dennis Dominic Ajay, on income from part-time teaching. Reference is made to the request of the Appointment Committee during the vetting of the Supreme Court nominee, Sir Dennis Dominic Ajay, regarding the payment of tax on income derived from his part-time teaching. Sir, under the Income Tax Act 2015, Act 896, as amended, the income derived from part-time teaching is subject to final withholding payment at the rate of 10%. Section 116A(2) and 1191F and paragraph 8C(2) of the first schedule to the Act 896. The obligation to withhold is on the withholding agent, that is the payer of the amount, and not on the withholdee, and it is done at source, that is at the time the amount is paid or payable. Section 1161 of Act 896. Once the tax has been withheld, that satisfies the tax liability of the withholdee under Section 1(1)(b) of the Income Tax Act, because it is a final withholding tax. Section 1192A of Act 896. The withholdee, Sir Dennis Dominic Ajay, is not required or obliged to declare that income on the tax clearance certificate, into bracket TCC, because it is a final tax as stated earlier. Therefore, the tax clearance certificate issued by GRA reflected his income earned for the period the tax certificate was issued. Thank you. Yours faithfully, Mrs. Kate Nto Kimbu, Sub-LTO Manageress for the Commissioner of Ghana Revenue Authority. Thank you very much. I will then proceed to acknowledge. Honorable members, I will then proceed. Order. I will then proceed to acknowledge our revered guests. First on the list is Mrs. Dorothy Mensah. Order. Let there be order. Please, Uma, let there be order. Please, Jerry, let there be order. Mrs. Dorothy Mensah, Mr. Philip Bright Mensah Jr., Bishop Dr. Abak Wilson, Mr. Charles Aidan, Deputy Director of Finance, Judicial Service, Dr. Ebenezer Akwabentel, Oketechie, Professor Amemfi, Omanhini, Asebu Traditional Area, Nana Amemfiwa, Queen Mother of Asebu Traditional Area, Nana Bochrewa Ikumbri, Ebusiapenyi, Nana Edweful, Justice Christopher Archer, Her Ladyship, Jennifer Abena Dazi, His Lordship, Jerome Noble Nkrumah, His Lordship, Anthony Opon, His Lordship, the Acting CJ Justice Paul Bafoboni. You are all welcome. Honorable, very well. I do not have the name of Justice Yoni Kulendis, but I have been informed that he is here. He is in a mask, so there is a difficulty recognizing him. I recognize the presence of Justice Yoli Kulendis, Justice of the Supreme Court. I'm also informed that Mrs. Bafoboni is also here. On my own behalf and on behalf of the committee, you are warmly welcome. Very well, I recognize all the Queen Mothers, those whose name I do not have here. There will be difficulty mentioning your name because I do not have your names here. Forgive me, you are also welcome. Honorable nominee, on behalf of the committee and on my own behalf, we thank you very much for attending upon the committee and providing answers to questions. We are also happy for your endurance. We've gone beyond a stated time, but bear with us. You will surely hear from the committee. You are hereby accordingly discharged.
Thank you so much for the opportunity to meet you. Thank you.